Hi, my name is Chip Parker. I'm a consumer bankruptcy attorney from Jacksonville, Florida. Today I'm going to talk to you about the differences between a Chapter 7 and a Chapter 13 bankruptcy. Those are the two major bankruptcy chapters available for consumers. Now, a Chapter 7 is known as a straight liquidation bankruptcy. A Chapter 7 can be filed by not only consumers, but by corporations as well. And in Chapter 7, a consumer gets to wipe out all of his or her unsecured debt. Now, with respect to secured debt, if you are current on your secured debt, like a house or a car, then you just continue to make those payments in Chapter 7 and everything will be just fine. A lot of times, an automobile finance company will require a Chapter 7 debtor to execute something called a reaffirmation agreement, and that reaffirmation agreement basically says whatever you owed the finance company before you filed bankruptcy, you owe that now. However, it is as if you never filed bankruptcy on your vehicle, for instance. Now, with respect to a Chapter 13 bankruptcy, not only do you get to wipe out your unsecured debt, but you also get to restructure to a limited extent your secured debt. For example, people use Chapter 13 when they're behind on their automobile or home payments. In Chapter 13, if you are, say, $15,000 behind in your mortgage payments, you file a Chapter 13, you'll be able to repay that arrearage over a period of up to 60 months. And during that same period of time, you'll continue to make the normal monthly mortgage payment. With respect to automobiles, those automobiles get re-amortized over the same 60-month plan period. So let's say that you have an automobile and you owe $15,000 on the car, and you have an interest rate of 9% and payments of, I don't know, $500. What we would be able to do is reduce that interest rate down to a lower rate like 6% and take that $15,000 and re-amortize the loan over a period of 60 months. Now, the great part about that is you are going to end up with a significantly lower car payment, and you'll be able to use that difference from what you were paying on your car to what you will be paying on your car. That difference will be used to offset the arrearage that you're going to have to pay back on your home. So it's not as onerous as you might think. Now, a lot of people, a lot of my consultations, or a lot of my debtors are confused when they first come to meet with me. They've been told that, no, in Chapter 13 you have to pay back all of your unsecured debt. That is not true. You have to commit all of your disposable income to a Chapter 13 plan. What is your disposable income? The disposable income is that amount of income which is left over after you've paid all of your expenses. What are your expenses? Well, obviously your taxes and insurance, but also allowances for food and clothing and gas and utilities and all of that sort of stuff. So you're going to have a gross income. You're going to subtract out all of your allowable expenses, and you're going to come up with this number there at the end. And that number, that's the amount that you have to contribute to the unsecured creditors. Let's say that you have $60,000 of unsecured debt in a Chapter 13 bankruptcy, and let's say that based upon your income less your expenses, you have $50 left over every single month in what is known as disposable income. Well, that $50 would be paid to unsecured creditors over the 60-month period. Well, if you do the math, that's only going to add up to $3,000 over a 5-year period. What happens to the remaining balance of all this debt? It's wiped out. So, Chapter 13 is longer. It's 5 years typically, It's more expensive. In my case, I charge more than double for a Chapter 13 because I'm in the case so long. And a Chapter 7, by contrast, is 4.5 or 5 months. It's cheaper, but you also have to qualify. And a bankruptcy attorney can tell you whether or not you qualify to file Chapter 7, but you're going to have to pass one of two tests. You're either going to have to pass what is known as the median income test or the means test. The median income test is very simple. Every bankruptcy attorney is going to have a chart that is going to show what the median income is in your state for a household size of 1, 2, 3, 4, 5, 6, 7, 8 people. And what you do is you compare your household size with a similar household size, and if your income is below the median income, you automatically qualify for Chapter 7. Now, if you don't qualify for Chapter 7 under the mean or the median income test, then your bankruptcy attorney is required to run a very complex calculation called a means test. Now, that is a 56-part, many pages long test that draws in data from the IRS and from your actual income and expenses, and there are certain allowances that are afforded to you by Congress, and as a result, your bankruptcy attorney is going to crank all of this stuff into a formula and complete this very complicated means test and will come up with a number. That number is your disposable income. If your disposable income is more than $167 per month, you fail, and you must either not file bankruptcy or file a Chapter 13 bankruptcy. If you file a Chapter 13 bankruptcy, then the court and the trustee are going to look to that disposable income that was calculated in your means test to determine that that's the amount of money you have to pay unsecured creditors, but not so fast. There's plenty of case law out there that says that judges look at your actual income versus your actual expenses, because one of the things you'll learn about this means test is that it is not an accurate indicator of your actual disposable income. So fortunately, judges have interpreted the statutes to say that in many cases, in many jurisdictions, the court is able to look at your actual income as a matter of, your actual disposable income. And as a matter of fact, in many jurisdictions, including Jacksonville, you are allowed to deduct from your income in a Chapter 13 case your 401k withholdings. And if you are paying a 401k loan, you get to reduce your income by the amount of the loan repayment. So, Chapter 13 versus Chapter 7, if you don't have to restructure secured debt, you're going to want to try to file a Chapter 7. And if you are behind in secured payments, or you have a second mortgage that you want to try to wipe out, then you should talk to your attorney about filing a Chapter 13 bankruptcy. My name is Chip Parker. My email address is parker@jackslawcenter.com, and I thank you for listening.